Good afternoon and welcome to our Doctrine and Diversity event today. We're very pleased to have you here. My name is Gregory Bowman. I have the honor and privilege of serving as the Dean of Roger Williams University School of Law, and I'm going to start us off today by reading our law school's land and labor acknowledgement. So as we begin our program today, I want to take a moment as we start to reflect on the lands on which we reside. We are coming here today from many places, and we want to acknowledge the ancestral homelands and traditional territories of the indigenous and native peoples who have been here since time immemorial, and to recognize that we must continue to build our solidarity and kinship with native peoples across the Americas and across the globe. Roger Williams University School of Law is located in Bristol, Rhode Island, and so we acknowledge and we honor the Narragansett and Pokanoket people, as well as Soams, the original name of the land on which our campus resides. We also acknowledge that this country would not exist if not for the free enslaved labor of Black people. And we recognize that the town of Bristol and the very land on which our campus resides have benefited significantly from the trade of enslaved people from Africa. The economy of New England, of Rhode Island, and more specifically of Bristol, was built from wealth generated through the triangle trade of human lives. During this time of ongoing national reckoning with our history of slavery and the disparate treatment of Black people, we honor the legacy of the African diaspora and the Black lives, knowledge, and skills stolen due to violence and white supremacy. As we gather here today, the movement for justice and liberation is building within our country. Yet many are still being met with violence and even being killed, while other people in our country actively work to stand in the way of progress. As upholders of justice, our hope is to become agents of change for members of our society who have been met with violence, physical, mental, emotional, through our privilege. And as upholders of justice, we believe that our students, who soon will be practitioners of law, can be and already are agents of change as well. And now it is my pleasure to turn the virtual podium over to my colleague at Roger Williams University School of Law, Professor Nicole Dyszlewski. Nicole?
Thanks, Greg. Hi, everybody. Good afternoon or morning, depending on where you are. It is that time of year during the semester when everyone is sick and it's midterms, so apologies for being a little hoarse. Welcome to the second event of our third year of the Integrating Doctrine and Diversity speaker series. I'm Nicole, the moderator of the session, and today's session is titled, How Does Diversity, Equity, Inclusion, and Belonging Pedagogy Fit in Business Issues and Financial Affairs Classes? Although, because that is a mouthful, I will generally shorten it to money classes. I want to start by saying thank you to our event sponsors, RW Law, CUNY Law, Jurist, Berkeley Law, and GW Law, and also thanks to Greg for kicking us off. Before I begin with the panelists, I just want to frame the discussion by explaining why we chose the topic today. Since we've been working on integrating doctrine and diversity in 2017, we've gotten some pushback from professors who teach money law classes that say that diversity issues don't belong in or fit well in these type of classes. I obviously totally disagree with that, but I also don't teach any classes that are business issues or financial affairs, so my point of view in this is of limited utility. Convincing professors of my point of view never really seems that helpful anyway. Instead, what seems most effective is to show professors how it can be done in a pedagogically sound way by experts who are already doing this work. So today we have those experts who teach a variety of money law classes at different institutions who will talk about ways in which they integrate doctrine and diversity, equity and social justice issues into their classroom discussions, assigned materials, and curriculum. My first question is for Gigi. Gigi is joining us only for the first part of our webinar today, because she's due in court shortly. So I just wanted to make sure she knew we appreciated her time. And if you have any follow-up questions about her scholarship, please feel free to email her directly. Gigi, this summer you presented at SEALS and you blew my colleagues away with your presentation about narrative justice. In your 2019 Michigan Journal of Race and Law article, you stated, there is significant legal scholarship addressing employment issues such as discrimination, disparity, and harassment. However, the human voice in these battles, their stories, their emotional, cultural, and individual journeys are sometimes displaced for reasons of logic, practicality, or purported irrelevance. How can we examine the law, its complex rules, terminologies, and traditions in a way that includes these histories? Moreover, why, some may ask, does their worldview belong in the space of law? It is my hope that narrative justice can begin in law school. We should teach students how to analyze laws and regulations with a narrative justice pedagogy, encouraging in-class presentation of students' findings with respect to social justice issues. In turn, these new lawyers will be better prepared to listen to and articulate their clients' stories. Gigi, welcome, and can you please share a bit about how you see narrative justice as a pedagogical tool that teachers, specifically teachers in business issues and financial affairs classes, can use in their classrooms?
Well, thank you so much first, Nicole, for having me, and Roger Williams University Law School for having me and inviting me to speak with these amazing teachers and scholars. It's really such a privilege. Thank you so much. And apologies again that I have to be in court soon, so I'm going to log off, but I'm looking forward to also watching the recording afterwards. So narrative justice is a term that I created in 2019 when I started the Narrative Justice Project. So the Narrative Justice Project is fiscally sponsored by the New York Foundation for the Arts. And the purpose of the Narrative Justice Project is a space for artists and activists in law, policy, and business to collaborate on issues of social responsibility. So with narrative justice, the point, as Nicole explained, is to include all voices and stories and to make sure that they're authentically told and heard so that justice can prevail. So it's not about picking a side in court or at the table. Narrative justice is ensuring the dignity of all of the parties in a litigation or transactional deal, that they have a seat at the table and that they have access to the microphone. There are countless contract and business law cases that leave a hint of an untold story or an undeveloped analysis based on a narrative thread in the case that doesn't get the light that it deserves. I highlight these subtle hints in my classes, such as through the Lucy versus Zemmer case, which I'll talk about in a little bit. But talking about the cases from an alternative perspective and the alternative narratives gives students the autonomy and the freedom to learn how to listen effectively to their clients and to creatively think of new and innovative arguments to change the law for the better.
I love that because I think sometimes we don't share the value of creativity as a legal value. And for me, this gets me really excited because it helps connect the students to the material. And it also encourages creativity. Can you tell us what classes you teach? And can you give us an example of how narrative justice might work in one of your classes? And if you have any scholarship about narrative justice you recommend or are working on, are you able to share that with us?
Yeah, so absolutely. So I started out teaching through the Narrative Justice Project and through my master's. I have a master's of fine art in addition to a law degree. So I started out teaching a class that I called Law, Literature, and Justice. So it was an immersion of analysis of poetry and flash fiction and laws and regulations sort of side by side. I started with that course, and now I'm entering my 4th year at Widener University, Delaware Law School. I teach contract law and business law, otherwise known as corporations. Those are the core courses, Contracts 1 and Contracts 2 in business organizations. And I also now teach a 3-week intensive summer course, Corporate Social Responsibility. So those are the main courses that I teach. And how I apply narrative justice in the classroom is a type of brainstorming for how the law student as a future attorney can highlight an unsung narrative. Chelsea, is it possible to bring up my my slide on the Lucy versus Zemmer case? So basically, if we use the Lucy versus Zemmer case as an example, it's a major case taught in almost every first-year class in contract law that students are familiar with. And what I like to highlight in the Lucy versus Zemmer case so here's the case. So the reason that the transaction was enforceable was because the judge decided that it actually wasn't a joke when the offer was made of the sale of the farm. But while the court indicates that the wife strongly dissented from the sale of the farm, it's not considered in the court's opinion for why perhaps the transaction should not be enforceable. So a form of narrative justice in contract law is to ask students to analyze this case from the wife's perspective, from the counsel for the wife's perspective, how one would advocate for her in this transaction and in future transactions going forward. Another case, if you could turn to the Bohach case, it has the slide with the woman. Great. So this is a case that is taught in corporate law, in business organizations. So this case involves the acceptability of letting a female partner leave, or basically terminating a female partner at a law firm because of a fundamental schism. So the question, it was acceptable to the court that she be terminated because there was a fundamental schism between the partners and they needed to have a working relationship. But what I ask students to consider is, why is it acceptable to terminate someone because of a fundamental schism? How do we think outside of the box for different types of counseling or co-counseling or training programs? If you're able to turn back up to the slide with the formality poem, that would be really helpful. It's one of the first slides. So in the Bohach case, I often ask students to think creatively of different ways that this case could have been decided, how a decision could have been rendered. And so if you look at the formality poem, I think it's in slide 3. That poem is basically about a woman struggling with being forced to leave an employment situation and the trauma involved. And I like to highlight that poem in relation, yep, it's right there. I like to highlight that poem in relation to the Bohach case as a form of narrative justice to convey the narrative of the female partner that had been let go from her position because she spoke up about an ethical issue that she was concerned about. So these are some ways that I include narrative justice in the contract and business law classes, because oftentimes they're money classes, there's a lot of money involved, but there's also emotion involved, and there's also nuanced relationships between people at the corporation or at the firm. And it is possible to work together so that it does not end up in significant litigation or termination of a partner. And so narrative justice is a way for helping students think outside the box when we review these cases. Thank you so much. You can stop the slide. So in addition to analysis of the cases, I often sometimes bring in YouTube videos. For example, there's a case in corporate law, the Occidental Petroleum case from the 1990s, where a shareholder was disputing whether a donation to a charity for a museum was a violation of a breach of a fiduciary duty. So we have a YouTube video that we watched recently in corporate law talking about how now Occidental Petroleum is entering into climate justice deals with a recent acquisition of carbon engineering to help further climate issues. So there are many ways that we can incorporate DEI in contract and business law classes. And I encourage other faculty members to share also with me if they have ways that they do it. I'd love to take notes from other faculty members as well. But those are some ways that I include narrative justice. Oh, sorry. Sorry, I think there was a national broadcast alert.
Yeah, we got the email earlier today that they're going to be pinging our phones all at the same time. And, you know, technology does what it wants to do right in the middle of when you're talking about narrative justice.
But so I have an article coming out in 2024 with Oregon Law Review on defining narrative justice, and it gives some interesting ideas to think about for incorporating narrative in contract and business law classes. You can find it on SSRN. A draft of the article is on there. Thank you.
All right, thank you so much. So I'm going to take Gigi off the hot seat, and I am going to put Bridget on the hot seat. My next question is for Bridget. I think it would be safe to say that I am a total fangirl of Bridget. Since the moment I learned of her work, I have not stopped emailing her to come and talk at every event I can think of. She is the co-editor of a series of feminist judgment books, and specifically the co-editor of Feminist Judgment's Rewritten Tax Opinions. In the preface of that volume, she writes with a co-author, "Most people understand that feminist reasoning has tremendous potential to affect, for example, the law of employment discrimination, sexual harassment, and reproductive rights. Few people may be aware, however, that feminist analysis can likewise transform tax law, as well as other statutory or code-based areas of law. By highlighting the importance of perspective, background, and preconceptions on the reading and interpretation of statutes, Feminist Judgment's Rewritten Tax Opinions shows what a difference feminist analysis can make to statutory interpretation." Bridget, welcome. And can you tell us which classes you teach, and can you talk about the Feminist Judgment series generally and the tax volume specifically?
Well, thanks so much, Nicole, and fan back to everybody on this panel. It's exciting to be with people whose work I cite and very much admire. So thank you for organizing. So I'm at Pace University School of Law in White Plains, New York, and I teach federal income tax, tax policy, estate and gift tax, corporations and partnerships, wills, trusts, and estates. So money law is exactly my specialty. And at the same time, I also teach feminist legal theory. And feminist legal theory is undergirding this wonderful, collaborative, amazing project that involves over 250 law professors of all parts, from all parts of the legal academy, trying to rewrite from a feminist perspective decisions that courts have issued. Our first book was about Supreme Court decisions, and we've since branched out into specific subject matters. Nicole mentioned the tax volume. There's a trust and estates volume. There's a corporate law volume. There's a property law volume. There is going to be an immigration law volume. And each of these books includes a commentary and a rewritten opinion using all of the same facts and precedent in effect at the time the original decision was issued, and trying to show through feminist reasoning how the result might have been the same or different, but really showing, not telling, how things can change, just like Gigi said, when you emphasize different narratives, when you emphasize different perspectives, sometimes you get to the same results, but sometimes you get to different results. And we really approached feminism as the broadest, in the broadest sense, as an inclusive social justice movement. So I teach money law classes and these feminist judgments books because they include a rewritten case and some commentary situating that case vis-a-vis the original, make for very, very ready exercises if you'd like to integrate a critical perspective into your class. And quite frankly, it's easier to integrate critical perspectives into your class when the text is doing it for you. For folks who are untenured, not on the tenure track, and folks who are tenured, who don't fit some old-fashioned stereotype of what a law professor looks like, sometimes it's hard for us to introduce critical perspectives. But when you can let the text do the talking for you, students have an easier time buying into it.
That's great. And I'm really glad that you mentioned that. I have heard a lot of people who are on the tenure track exhibit some anxiety about doing anything sort of different or new because they feel like they are being judged by a sort of an old standard. And I am not on the tenure track, so I don't sort of live with that. But I do think it's good to sort of mention it. I also know the decisions we make about our content can also be impacted by our own identity. And so I think that's helpful to point out here. But Bridget, can you talk about how a professor might actually use one of these feminist judgments in a doctrinal class, or can you give an example of how you might have used one in a class?
Oh, yes. Thank you so much. I love using feminist judgments in a course. And actually, our colleague Morgan Beltra just put into the chat a little memo, a little short teaching exercise that I prepared and can share with everyone for how to do this in your class. So this takes as an example a rewritten opinion by David Brennan of the University of Kentucky, currently visiting at Florida. And Professor Brennan rewrites a decision in a very famous tax case called Bob Jones, which denied tax-exempt status to a university that discriminated on the basis of race. And he explains from a feminist perspective how, or he writes from a feminist perspective about how racial discrimination and gender discrimination were intertwined in that case. One amazing thing you can do with students is either take a case that's in the casebook or one that's not in the casebook and present it to students along with the feminist judgment without telling them which is which, and ask them to read both and say, which do you think is correct and why? Which reasoning is stronger? Which shows greater sensitivity to the legal issues and the perspectives of the parties? And the students will chime in, and then one can reveal, or maybe you want to lead with the fact that one is a fake opinion. But it's very, very powerful to show that using all the same facts and all the same law, you can reach different results. It depends on values and priorities, something I think we all know in the back of our minds, but it is becoming more and more obvious how values-driven legal decisions are the hallmark, at least, of this Supreme Court. And so making the space for those values to come into the law school classroom is extremely important. And I've got some discussion questions that you could use to spark conversation in your class, using just this one example of a university that was denied a tax exemption.
Thanks. I was talking earlier today to Natasha, and we're at this like interesting place where after the ABA changed the standard and we're on purpose supposed to put more diversity or racism places to discuss this in the curriculum, and we're also all looking towards next gen, having these exercises is so helpful because we're all sort of thinking about this in the moment. So thank you so much, Bridget. And my next question is for Kiva. Kiva, I'm really excited to add you to the conversation. In your 2022 article, Black Assets Matter, you powerfully state, quote, Black assets matter because they have power to shape identity, the power to employ members of the community, the power to influence policy, and the power to create generational wealth. In other words, Black assets have power. Hence, it's essential that financial literacy be an integral part of every K-12 educational curriculum. Additionally, we must educate Black attorneys and law students about the need for and importance of transactional expertise. Eradicating the racial wealth gap remains a significant aspect of civil rights work in the 21st century because structural change in the economic system requires addressing the legal system designed to protect it. What I really liked about this piece is that you see educating law students as not separate from, but part of eradicating the racial wealth gap. Can you share with us which classes you teach and share about how you integrate conversations about the racial wealth gap into these classes? And can you give any specific examples of how you do this in your classes?
Certainly. Thank you, Nicole. I'm delighted to participate in such an important conversation, and I appreciate the invitation. As a homecoming, I began my teaching career at Roger Williams University, so it's lovely to return home. I teach wills, trusts, and estates, federal income taxation, and contracts at Howard University School of Law. As you know, Howard, central to our mission is that of social justice, racial justice. And so I integrate conversations about the racial wealth gap into these classes in a variety of ways. For example, in wills, trusts, and estates, I created a very short PowerPoint presentation highlighting some of the graphs that are noted in the article that you mentioned, Black Assets Matter. And so one of the graphs highlights the racial wealth gap, and most law students are astounded to learn that the average wealth of a white family is 8 times the average wealth of a Black family. And even more shocking to most students is the graph that reveals that education is not the great equalizer that many of us would think with regard to wealth, because on average, a white high school graduate has more wealth than a Black person with a graduate degree. And so providing these statistics from the Federal Reserve, kind of an objective, credible source, is very telling, revealing to the students, and that opens up a conversation about generational wealth and what is the role of wills in retaining that generational wealth and their role as potential future trust and estates attorneys in that process. And we have that conversation early in the semester. In federal income taxation, I take a bit of a different approach where we do an exercise looking at Code Section 1, which lays out all of the various tax rates. And we posited 2 individuals who are at the exact same job, in the exact same position, making the exact same salary. I usually say they're in cubicles next to one another. And let's calculate what their tax liability is. One individual is married, one individual is single. And usually that reveals some very different numerical calculations. And it invites a conversation, which most students are surprised to learn that there is a difference based on one's marital status. And we think about the implications of that from diversity and the diversity of families. Marriage equality would often be a topic of conversation in light of that. Equity with regard to family structure and status. And so these are just a couple of ways that I utilize class time very early on. But I do want to echo Bridget's point, which I think is so important. And I was told very early in my academic career, which is casebook selection. I've had the privilege to use Bridget's casebook that she has co-authored with Dorothy Brown and Joel Newman for federal income taxation. And it certainly is easier to integrate some of these critical perspectives and conversations when the text is doing it for you. And so as a professor, you're simply following the casebook as opposed to kind of creating an alternate path. So I do want to encourage everyone to be very intentional and deliberate about their casebook selection. I believe that will be an aid in those conversations. Finally, what I also suggest, I often engage students to participate in my scholarship, which explores some of these issues of diversity and equity and inclusion and belonging. For example, I was part of a working group that prepared a report called Strengthening Probate Administration in the District of Columbia, and perhaps that could go into the chat. And this report focused and identified a range of legislative and regulatory and policy changes that would aid the citizens of the district, especially those who navigate the probate administration process without legal counsel, so pro se litigants. And so a number of students were able to engage in community work in that regard, which was a very tangible way to explore DEIB issues in these money law classes outside of the classroom as well.
That's great. When I was taking comm law, my comm law professor would give us copies of what he was working on, even if it was not related to what we were learning, so that we could read what law professors do when they're in the middle of doing it. And he solicited feedback, and it was a great way to feel sort of more connected to the work we were doing and also to him. So thanks for sharing that, Kiva. I'm going to bring in Natasha, who's one of my colleagues here at RWU Law. She is in the middle of teaching this semester wills, trusts, and estates, and has a specific approach to the topic, which I thought would make her a great candidate to talk to us today. Natasha, can you tell us what classes you teach generally, your perspective on teaching diversity, equity, and social justice in wills, trusts, and estates, and specifically, how much of this perspective do you tell your students in the syllabus or in the class itself, and what reactions does this elicit?
Yeah, well, so first, I'm so excited to be a part of the Integrating Doctrine and Diversity series. This is, as you said, my first year at Roger Williams Law, and I've been a fan of this series since its inception. And particularly, I'm grateful to be a part of this panel, which is a superstar panel. So I'm very grateful also to be, I did contribute to the Feminist Judgment series, but in the property section and the property book, which I use, but I mentioned to Bridget earlier, the tax one is the best one. So to answer your question, in wills, I think for me, tone setting is really important. And so I tend to be pretty upfront about it. And particularly this year, one of the things I start off doing is the very first assignment is I ask the students before they've had any instruction in any wills, trusts, and estates. I ask them to just write a will based on what they know about themselves, what their values are, what they have that's important to them. I give them some general sort of instructions about think about what's important to you and what you might like to happen. And then I ask them to just, based on what you know, dispose of your property. And then in the very first class, I also assign an article by Ritu Peepoff, who is one of the, she's in the senior leadership of the American College of Trust and Estate Council, or ACTEC, which is the acronym that I will use. And she has written an article about sort of racial disparities in estate planning. And so when we talk about what they've done in their wills and talk about sort of the systemic impacts of estate planning, it's a really nice way to bridge sort of what happens in practice with the things that they dealt with when they're thinking pragmatically about their own lives and property. Because the thing that happens when I ask them to think about their own property, the common responses I get from them are, I can't do this. I don't have anything, right? I don't know anyone to give anything to. I don't have any property. This doesn't make sense for me. The article that we read that I assigned for class really thinks and talks about the importance of estate planning in communities where it doesn't happen, and thinks about why it's important and talks about the way that when estate planning doesn't happen, ownership shares get fractured, which creates an opportunity for developers to come in and buy a small portion of ownership and then buy out the rest of the owners. And it's something that really has over and over and over again contributed to gentrification of neighborhoods that were formerly minority owned. And sort of seeing the connection between the things that students have said about, well, estate planning doesn't matter for me, I don't have anything. And an article that says, well, when people don't engage in estate planning because they think they don't have anything, and it can still have sort of disastrous impacts for communities, it's a really nice way to sort of underscore the importance of estate planning in particularly communities of color. So the two things that I always say over and over again in whatever classes I teach are that words matter, because they do for everyone, but especially for lawyers, and that relationships are everything. And so this semester I'm teaching wills, estates, and trusts, and also contracts. But I have also taught various courses in tax, federal income tax, and also some state and local tax, and some seminars on e-commerce and tax. And I've also taught in the area of critical race theory. And so in all of those classes, I'm really thinking about the power dynamics that emerge, particularly when we think about money and the things that people value, and the way that these dynamics emerge when the things that we value are at risk, and the way that people respond when they feel like they're losing control of the things that matter most to them. And I want to really echo things that Gigi have said about sort of the hidden narratives that are in our cases. I really encourage our students to think about, well, what are the stories here that we can see if we look carefully, but aren't really hitting us over the head in these cases. And I also have this framework where I ask students to notice, particularly in wills, we have a lot of cases where we have judges thinking about, well, here are the reasons where it's really important to stick to the formalities of the will, right? Somebody didn't sign it, so we can't really respect the intent of the testator because the formalities weren't respected. And then other cases where the court will say, we're going to set aside the formalities because we know what the testator wanted. And I will ask the students to sort of make sure that they're keeping track of the identity of the testator, and notice that sometimes it's gender, sometimes it's race. And when we set aside the intent of people, we notice something about who we trust and who we don't. We just to sort of keep track of what we do. And without sort of making any value judgments myself, I think just encouraging students to start noticing things like that is a really powerful thing. And I think it's easy to miss if you don't do it. And in a similar vein, I encourage them to notice sort of the way that case books and judges and authors, even in different times and spaces, refer to parties, they will refer to men differently than they will to women, either using first names or no names sometimes, or the casual way they refer to parties, or not at all. So it's things like that. But in general, I think for me, the tone of the class is one where we're always sort of thinking about the dynamics that exist between parties and who is showing up and who is not there at all. In particular, I think when we, and I want to sort of also really amplify what Kiva and Bridget were saying about the choice of text, right? And I love Professor Brown and Professor Crawford's textbook, but also there's work that people have done outside of the actual text that's really wonderful. I bring in The Whiteness of Wealth into a lot of my classes, just excerpts of it, when I think about the way that our value systems are embedded in our tax code. Thinking about, if you're married or not married, that's an incentive, right? Our tax code provides incentives and deterrents for some kinds of behaviors. And so those discussions really set a tone in the class and get students thinking, moving forward about, well, what are we doing here with these kinds of policies? So those are the kinds of things I really encourage students, whether we're talking about cases or engaged in sort of a legal analysis skills exercise, to always be thinking about not just about how courts are acting and moving, but about why they're acting the way they are, and what that tells us about the systems and structures around us, and what they can do about it. I really want students to feel empowered, because they're going to be members of the bar. They're going to be the people who are making these arguments to court. And I want them to feel empowered to make arguments that are culturally responsive, and that are the ones that can be winners. So that's what I'll say about that.
Thanks. And last but not least, I'm going to add Deborah to the conversation. In the next Integrating Doctrine and Diversity book, Integrating Doctrine and Diversity Beyond the First Year, coming soon to bookshelves later this fall, you wrote an essay titled Identifying Bias, Inequity, and Discrimination in Insurance Law, with some thoughts on doing the same in a business associations class. Where in that you beautifully stated kind of what I started off by saying. You say, quote, "I'm always amazed when I hear professors and lecturers who teach in the business and commercial law fields say they do not think issues of diversity, equity, inclusion, and belonging fit into their courses. On one hand, I kind of get it. The issues may not be as plainly evident as they are in courses such as Con Law and Crim Pro or even property. But on the other hand, perhaps because I am a former diversity, equity, and inclusion administrator, I am well aware it takes almost no thought to recognize that there are several issues related to bias and discrimination that can arise in any area of law, and particularly in business law courses, where there are often issues of power, institutionalized bias, and discrimination." End quote. Your perspective as a former DEIB professional, as well as a current money law professor, is so valuable. Deb, can you tell us what classes you teach, as well as can you share an example of how you teach about these issues of power and diversity, inequity, and social justice in an insurance law class?
Sure. So thank you, Nicole, and hello to everybody. And I will echo what others have said, and just saying thank you for allowing me the opportunity to speak. And I'm going to echo what Kiva said in terms of a sort of welcome home, because I also started my career at Roger Williams as a diversity and equity and inclusion professional, as an administrator, and have since moved over to the faculty. But I think, Nicole, to answer your question, first of all, when I think about money courses, right? Money, our courses, our classes, and I think about money, I think about power and access and control. And so I think about those things when I think about the law as well. And so I think that's why, for me at least, it's hard to not see the two coming, the DEIB issues and issues around money and the law coming in or sort of fitting together. I've taught insurance law for a number of years. I first started teaching it at Roger Williams. I'm currently teaching business associations and a cyber insurance course. I've taught contracts, and I taught a legal skills and social context course when I was teaching at Northeastern. And, again, I see issues around power and control and access in all of these courses in one way or another. And so I think that it's important to think about, I think some of the pushback comes from, or some of the inability to see how these issues fit in, is when we think about strictly the doctrine, right? Because a lot of times, like, rules are rules, and they are, at least in theory, to be applied equally, right? And so when we're talking about rules that relate to money, as we're using the term today, that it shouldn't really matter who we're talking about. But I think that's a flawed way of thinking about things. In insurance law, I think there are a couple of ways that I talk about these issues. And so one of them is first to talk about insurance regulation. And I think when we talk about insurance law, we're often thinking about issues around liability, and we might be thinking about kind of property and how do we insure our property. But insurance regulation is a very significant aspect of insurance law. And so we start thinking about state agencies, right? The Department or Division of Insurance, and how they're regulating the operation of insurance companies, the management of insurance companies, the sale of insurance in their respective states. And so, and regulation is about, insurers discriminate all the time, right? They're thinking about how do they develop their rates, right? And who's charged what premium. There's a form of inherent discrimination in that. And so whether we're talking about health insurance and why men may be charged higher premiums than women, or we're talking about auto insurance, right, where you're thinking about an automobile is often, or the insurance premium is tied to where the automobile is principally garaged, right? And so I talk with my students about, just using that as an example, well, what does that mean for those who live in communities, right, or in zip codes at least, that have higher crime statistics? And it's not to suggest that crime statistics the insurance industry should ignore those statistics. But what happens is that what is important is to think about, well, what is the impact of that? Because you have, zip codes that can be very broad, and the crimes may be concentrated in a particular area, and yet who is impacted by those higher premiums? What does that mean for individuals living in lower income neighborhoods? Often there's a form of discrimination. They're charged higher premiums that they may not be able to afford, that can influence or impact whether or not they're able to own a car. Can they drive to work, to the grocery store, to the doctor's appointment? And so, without getting too in depth, that's a way that I can talk through with my students, how issues, kind of DEIB issues, come into play. Who has access to insurance, right? Who is insurance available to? Thinking about thinking about it in that way, I think is important. I mean, I echo what others have said in terms of casebook selection. You know, one of the reasons that I use the book that I do is because I think there's a pretty decent focus on these issues, and having insurance regulation in the middle of the book as opposed to at the end where you're less likely to cover it, I think was a great strategic move by the editors. And so, you know, kind of having students think about that. Another way is that I will bring statistics into play. I mean, the last time that I taught insurance law within this past year, I just put some statistics up on the board in terms of, or excuse me, on our on the my PowerPoint slide, and I you know, we kind of walked through it and thought and looked at, okay, who runs insurance company, like who sits on the boards, who makes up the insurance industry as a whole when we're talking about leadership and management positions, right? Board positions, who are the officers and directors, and it's no secret when we're talking about whether it's insurance or other financial, the financial industry is still heavily male dominated, particularly when we go up the management chain, is heavily white male dominated. And what does that mean in terms of who's making the rules? You know, whose perspective is being considered when the rules are being made? And so, you know, my students on their own started kind of talking about that and thinking about, like, what language goes into the insurance policies? Whose language are we using? Whose narrative? To go back to Gigi's term, right? Whose narrative are we considering, or is being considered when policies are written or determinations are being made as to who gets charged what premium or not? So I think there are a lot. Those are just a couple of examples that I use, and one other one I just really quickly. I read to my students recently an excerpt from a 1960s article. I'm just going to read it really quickly. It's from a well-respected insurance scholar who wrote the following: "The insurance regulator is conceived by far too many insurance executives, and too often he conceived himself as part of the industry, existing to serve the industry. Indeed, I have heard life insurance men express the notion that it would be useful to have a national regulator to represent the industry in the executive branch of the national government. Nothing unsavory was intended. Whatever else one may say about the insurance business, it is a business run by honorable men. And however, the notion that a regulator should represent the industry is a subtly corrupted point of view." So that was written in the 1960s, and certainly we have to give, we have to acknowledge the time in which it was written. But when talking with the students, some of them are like, I feel like that could have been written today in 2022 or 2023. And so again, that's another way to kind of bring in some of the statistics that I just talked about, and students start to think about, well, again, what does this mean for who has the say-so to speak, with respect to creating the rules and creating the laws that deal with money, right? And determine who has access, who has power, and who has control. So those are just a couple of examples of ways that I integrate the issues into my insurance law courses.
Thanks. During COVID, I was helping with some of the technology, particularly with the adjunct teachers. And we had an adjunct teacher who was new to us, who is an insurance law practitioner, a Black male, come in. And on the first day, the first thing he said after introducing himself was like, "Okay, well, my first question to you is, would you insure the police?" And this was like fall 2020. And it just it blew me away that you could cut to the quick in insurance law so quickly. It wasn't like, let's go through the syllabus. It was like, this is something real. This is something relevant. It is related to social justice. And that is how we're going to start insurance law. And I was almost sad to not be there for the entire semester. Not quite totally sad, but like nearly sad. So this next question is for all of you. It seems like these issues of identity, power, social justice, inequity, diversity, and injustice are already in the subjects you teach. But it also seems like traditional pedagogical approaches to your topics and perhaps the case books and cases themselves ignore them, eliminate them, edit them out, downplay them, or move past them pretty quickly. Assume I'm a professor who's trying to integrate these issues into classes for the first time, but I'm scared and overwhelmed. Can each of you share like one case or one statute or one rule you might advise someone new to start with in your subject area? Is there a scholar or resource you would recommend? Is there any advice you might give to someone who's just taking their first steps towards prioritizing these issues in a money law class? And you can answer this in whatever order you choose. So if someone just wants to jump in.
I'll jump in, Nicole. For wills, trusts, and estates, I would encourage professors to consider the work of Professor Thomas Mitchell, who's on the faculty now at Boston College. He happens to be a Howard Law graduate, but he is the reporter and the principal drafter of the Uniform Partition of Heirs Property Act. And heirs property is really, a lingering issue of equity that Natasha was referencing as well, and has been the source of much tremendous Black land loss over the past century. And the legislation that his scholarship has led to has now been adopted in probably more than 20 states around the country, and is essentially trying to address some of those equity issues. So I would encourage someone just kind of venturing into the wills, trust, and estate space to consider Professor Mitchell's work. Of course, for those venturing into tax, I'm going to send you to Dorothy Brown. I'm going to send you to Bridget Crawford. I'm going to send you to David Brennan. I'm going to send you to Stephen Dean. Some of these, obviously, Bridget is on our panel, and Professor Brown and Professor Brennan, their work has already been referenced by panelists. And, I'll add Stephen Dean, who's now at BU's faculty as well, to some of the work that they have produced, their scholarship, and contemporary articles as well, some of their congressional testimony that has raised some of these DEIB issues also.
Thank you so much, Kiva. Next.
I should have gone before Kiva because all of those things that she just said, and I want to say that Professor Mitchell, that's sort of where I end. Like there's hope there. There's something that we can do about heirs property, right? And that's a nice place for students to feel like, oh yeah, I can do. This is why I'm getting this degree. I also want to say, particularly Professor Dean at BU just gave a talk about he works in the international tax space. And he gave a talk about, sort of colonialism and international tax that was really personal. So I guess my advice to you is sometimes students feel like money law, tax, and wills can be really impersonal and really just sort of dry. And I want to encourage faculty members to really call on stories, right? And that's why I think sort of Gigi's point about the narratives, the stories, that's the thing that really helps students to connect and feel like this is an area of law where it's really possible to make a difference, to do something. And sometimes, even though it can be really terrifying, using your own identity, calling on your own identity, and sort of connecting with students on a personal level, and saying, yeah, my life was changed when I read Stephen Dean's work, or Dorothy Brown's, when I read her book, it changed the way that I thought of something that I had worked for years in, right? Like I felt like I had been thinking about something wrong for a decade, right? And so really just bringing yourself to these things as well is for me the advice that I would give to students, because it really helps them to connect to you and the material, and it changes the way they hear you. But yes to all of Kiva's recommendations as well.
Oh, Bridget, you're muted.
I'm going to jump in and put a plug, of course, for the Feminist Judgments books, but more to the point, for the Feminist Judgments authors. One of the good things to come out of the pandemic is that we all got a little bit better about using technology. And if someone contacted me and invited me to speak to their class for 10 minutes via Zoom, the answer will always be yes if I'm free. And so for colleagues who are not super confident about raising issues on their own, sometimes having a guest speaker via Zoom or live can also be helpful. And so there are lots of colleagues out there who'd be willing to help start the conversation, and don't be shy about reaching out to any of us on the panel or folks who have written stuff that you like.
Thanks. I also want to plug, I heard, I think in 2020, right before the pandemic, BU had a symposium for a few days that really it impacted a lot of our work. And I believe it was Professor Peggy Smith who was talking about Comcast Corp, the National Association of African American Owned Media. And it was really her talking about this that really like sort of unclouded my own eyes about ways that the case we choose to bring home a point, we don't necessarily have to choose the same case the casebook chose. We can choose other cases. And so I don't know if she's written about it, but her talk there was really impactful to me. And was there anyone else who wanted to share other cases or authors?
I would just say for business associations, Carlos Chapman and Carla Reyes have a new BA book out, and I think that's an excellent resource as well, because they've been really thoughtful about which cases they include and kind of giving context and whatnot. So that's another thing to think of. And I love the suggestion about, kind of bringing in guest speakers to help. I mean, there are a number of topics that I feel comfortable talking about just based on my identity. There are others that I don't. And so having somebody else to, I have a former actually Roger Williams student who's been a speaker in a number of my classes, and who speaks from the perspective of being a Muslim woman. And so I think that's really powerful for my students. It's not something that I feel well equipped to talk about, but she does a beautiful job and even in a very subtle way, and just in her participation in the class, kind of raising issues that many students might not otherwise think about.
All right. Wow, we are at 3 minutes over. And I just wanted to say thank you to everybody. Sorry my voice is so froggy, but thank you to our panelists and to everyone who attended. Our next event is November 1st at 2 p.m. Eastern. I believe the topic is supplementing your casebook. And we really look forward to you being there. Thank you so much for our co-sponsors and for the people behind the scenes who make this happen. And again, especially to our speakers today.